could be admitted on behalf of the accused as part of the character exception. That is the exception to the admission of disposition evidence, and I'm referring to cases like R versus Lupien. And secondly, the proliferation of behavioral science evidence and its use by the Crown to bolster the evidence of the complainant. Concern for reliability and that there should be a threshold determination of reliability was first expressed by some trial judges, notably in R versus Miller-Agnew by Justice Moldaver, who's on the panel, and this eventually culminated in our decision in R versus Mohan, setting a threshold of reliability before expert evidence can be admitted. Whether this should be extended to civil cases or whether it should apply at all when the case is tried by a judge is still an open question. Now, these are some of the questions that the panel will deal with, and I will now proceed to introduce the panel. These will be brief, not that their qualifications are brief. We have a very distinguished panel. Mr. Justice Moldaver practiced criminal law for 17 years before being appointed to the Supreme Court Trial Division in 1990. Since then, he has displayed great insight into many fields, but particularly in the laws of evidence. And as I've said, he was one of the first trial judges to raise the issue of a threshold of reliability. He was also a keynote speaker at the recent Canada-US Legal Exchange, where this subject was also explored. Ian Binnie, QC, has already been introduced, as has Michelle Fuerst. David Butt, counsel to the Criminal Law Office of the Minister of the Attorney General. He is also a former law clerk both to the Chief Justice of Ontario and to a judge of the Supreme Court of Canada. Some people say that gives him too much of an edge. He's sometimes known as the Slayer of Askov. He is an expert in constitutional matters and appears frequently in the Supreme Court of Canada, where he has developed an enviable reputation for a counsel so young. I want to especially welcome Gregory Joseph and thank him for participating in this panel. He is a partner in the New York law firm of Freed, Frank, Harris, Shriver, and Jacobson. He has practiced both criminal and civil law, and as you can see from his curriculum vitae, he has been closely involved with the formulation of federal rules of evidence in the United States. He's a fellow of the American College of Trial Lawyers and was instrumental in the preparation of the paper on Daubert that is in the materials. He is also an author of a number of books and publications which are listed in the book that you've been provided with. Now we're going to start with Mr. Joseph, and he's going to tell us about the test for the admission of novel scientific expert evidence in the United States. Mr. Joseph.
Thanks, Your Honor. Can you hear me all right? Is this okay? Thanks. I'm going to be dealing with this in the federal courts. In the United States, we have a system in which the federal rules of evidence govern the federal courts, and each of the 50 states can have whatever rules of evidence they want to have, and the District of Columbia as well. But most states, 3/4, have adopted the federal rules of evidence. So the rule that I'm going to put up right now, Rule 702, is the rule, if you can read that, I'll read it to you if it's a little tough, that applies in most of the United States, in all federal cases, and in 3/4 of the states. And it provides, as you can see, if scientific, technical, or other specialized knowledge will assist the trier of fact, so it's a helpfulness standard, if it will assist the trier of fact to understand the evidence or to determine a fact in issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. So the federal rules of evidence take a very broad approach toward expert evidence generally, and they don't distinguish among different types. But as Justice Sopinka mentioned, there was a major Supreme Court case a couple of years ago, Daubert versus Merrill Dow, which focused just on scientific evidence, and specifically novel scientific evidence, and it said there are basically two tests. The first is it reliable? And the second is it relevant? And for reliability, it said, and this is a quote, "To qualify as scientific knowledge, an inference must be derived by the scientific method." All right, so you look at the method rather than the result to see if it's scientific. And then it has to fit the facts. You couldn't apply footprint expertise if it were a dental case. And then the last and most important thing that the Supreme Court said is that trial judges, civil and criminal cases, are supposed to act as a gatekeeper. They determine whether or not expert testimony comes in altogether. And those are two separate tests that are to be applied. The first is whether the reasoning or methodology underlying the testimony is scientifically valid. That's the methodology point I made initially. And the second is whether the reasoning or methodology can be applied to the facts in issue. So if you remember Rule 702 in Daubert, you could stand up and make an objection the way everybody does in the United States and just say, "Objection, it doesn't qualify under Daubert." And that is the short synopsis of a lengthy opinion, Your Honor.
Thank you very much. Michael Moldaver, do you want to tell us about the Canadian test?
Well, not really, but since you've asked, you might well understand how I feel, ladies and gentlemen, having to get into an analysis, a brief analysis of the Mohan case with the author of the decision sitting beside me. And as a result, I've decided to invoke my inherent jurisdiction. There's going to be an order excluding all moderators during the course of this answer. We have learned much from Mohan in terms of the admissibility of novel scientific techniques or theories when a proffer of that kind is made by one side or the other. Very briefly, because we've been talking about Mohan a lot, Dr. Mohan was a doctor, and I say was because I wrote the divisional court decision upholding his license revocation. But he was a doctor, and he was charged with sexually assaulting 4 patients ranging in age from 13 to 16 over a relatively short period of time. The sexual assaults, very briefly, took the form of breast fondling, vaginal stimulation, and the witnesses, or the victims, alleged victims, were basically consistent in terms of what had happened at the hands of Dr. Mohan. Dr. Mohan's defense was a complete denial. It wasn't that he was engaged in proper medical procedures. He just said, "I didn't do any of these things." After having testified to that effect, the defense sought to call an expert, Dr. Hill, to give evidence that the type of person that would commit these kinds of crimes must be either a psychopath or a pedophile, and therefore they would fall into a very small and behaviorally distinct category of persons. And of course, it was Dr. Hill's opinion that Dr. Mohan didn't fit either of these categories. In addition, Dr. Hill wanted to be able to say that because Dr. Mohan was a doctor, and doctors aren't supposed to do things like this, that even narrowed the category more. Unfortunately, in cross-examination, Dr. Hill had to concede that neither the medical or psychiatric communities had developed a standard profile for the offender who commits these types of offenses, and furthermore, that there hadn't been any scientific studies or literature relating to the psychiatric makeup of doctors who allegedly sexually assault patients. Well, the evidence was excluded at trial. Dr. Hill wasn't allowed to give it before the jury. Went to the Court of Appeal. Ontario Court of Appeal said learned trial judge was wrong. It should have been admitted. Went to Supreme Court of Canada. Supreme Court of Canada, in a decision authored by Mr. Justice Sopinka, said that the trial judge, excuse me, the trial judge had been right. And essentially what it did is it gave the Supreme Court an opportunity to talk about the admissibility of novel scientific evidence. And Mohan essentially set out 4 principles for the admissibility of this evidence, 3 of which, in my respectful submission to you, are commonplace. They apply to all experts, all opinion evidence. And I'll just briefly mention them. The proposed witness must be shown to have acquired special or peculiar knowledge through study or experience in respect of the matters to which he or she is going to testify. Well, that's clear. You've got to qualify your expert on the area in question. The evidence must be essential in the sense that the trier of fact likely will be unable to come to a satisfactory conclusion without the assistance of the expert. In other words, does the proposed evidence provide information which is likely to be outside the realm of the common experience of the trier of fact, their experience or knowledge. The third rule was that the proposed evidence must not run afoul of an exclusionary rule of evidence separate and apart from the opinion rule itself. And it's the fourth rule, though, that in my view is the critical one, and it is the one that relates specifically to novel scientific evidence or proposed evidence, and that is that the proposed evidence must initially meet a basic threshold of reliability. Now, what that means essentially to me is that the courtroom is not to be confused with the laboratory, and it's not the place to air speculative, theoretical, or invalidated hypotheses, whether those hypotheses relate to hard science or social sciences. But the one concern that I have with respect to the interpretation of Mohan is this. We know that there's got to be a basic threshold of reliability passed, but at page 423 of the judgment, Ms. Justice Sopinka said this, and just very brief, I'll read it to you. The trial judge should consider the opinion of the expert and whether the expert is merely expressing a personal opinion or whether the behavioral profile which the expert is putting forward is in common use as a reliable indicator of membership in a distinctive group. Put another way, has the scientific community developed a standard profile for the offender who commits this type of crime? An affirmative finding on this basis will satisfy the criteria of relevance and necessity. Now, it may well be that in view of that statement, the Supreme Court of Canada has essentially brought into being in Canada the Fry test as being the test that must be passed when one is considering the admissibility of novel scientific evidence. For myself, ladies and gentlemen, I have no problem with that concept whatsoever if it is the Crown seeking to lead new evidence, new scientific evidence, on a matter that goes to the ultimate issue. I have no problem with it at all. I do have some difficulty, however, positing that position to the defense. And I just leave you with this thought. Take the example of someone in the 1500s who was charged with heretical activity because she has said that the earth revolves around the sun. And her only witness available to her is someone by the name of Copernicus. Now, based on Mohan, Copernicus, there's no way Copernicus could get into the witness stand and give his evidence, and that poor woman would have been perfunctorily tried and hanged. She undoubtedly would have been pardoned posthumously. But based on Mohan, that evidence would not have been admissible for the defense, and with respect, speaking only for myself, I have some difficulty with that.
Well, we'll deal with Copernicus when he testifies. Mr. Joseph, does the test in Dolbert apply equally in civil and criminal cases, and does it apply if it's a trial before a judge alone?
They do apply. The rule of Dalbert does apply in all cases. There's some question whether, in fact, judges don't apply it a bit more strictly in criminal cases than in civil, and a bit more laxly in bench trials as opposed to jury trials. But the rules do apply.
Ian Binnie, I mean, I don't think there's any case in Canada that settles the point. What is your view? Should it apply in civil cases, and does it apply? That is the rule in Mohan with respect to a threshold of reliability.
Well, to the extent Mohan adopts Fry, I would have thought that on the civil side, they have already gone for the Dolbert test, but not explicitly. It's very rare, I think, that an objection is taken to this type of evidence in a civil trial, and when objection is taken, I think the tendency is to go through the various kinds of factors that were identified in Dolbert, of which one would be the acceptance in the scientific community.
Well, now I want to come to a fundamental policy question, and that is this. If expert evidence in respect of a novel scientific theory is helpful to the trier of fact. And helpful has now been refined not just to be nice to have it. It means that the jury really needs it, or the trier of fact needs it in order to come to a reasonable decision, because it deals with technical matters. Why should we have the trial judge act as a gatekeeper to screen out evidence that is not reliable? And Michelle, first, I'd like to start with you on that question.
Well, the courts both in Mohan and in Dobert have recognized that testimony that's dressed up in scientific jargon and presented by a witness who has impressive professional credentials can be very powerful. By definition, when we talk about expert evidence, we're talking about an area of evidence that's dealing with a matter or matters that fall outside the knowledge of the trier of fact. And juries, in particular, and often judges, I would suggest, are going to have trouble evaluating that kind of evidence. The problem is that evidence which lacks a firm scientific foundation may well sound very, very impressive to a trier of fact, but nonetheless be misleading if it has, in fact, no valid or no scientific validity attached to it. So I think, as the court in Dobert noted, it may well be that it assists the development of science to say we're going to consider theories or hypotheses that ultimately turn out to be wrong. But that is of very little use when we're dealing with legal issues and with the so-called legal search for truth about past events.
David Butt, what is your view?
I agree that you have to be aware of the differences in sort of the modus operandi of the scientist and the courtroom litigator or judge conducting a forensic inquiry. I mean, one of the essential aspects of conducting scientific inquiry very often is this notion of serendipity. In other words, we're trying to find out something we don't know. Let's be a little bit creative. Let's try some wacky new idea and see if that advances our knowledge in any way. And if it doesn't, well, okay, no harm in trying. But if it does, we've had a breakthrough. We've had a breakthrough as a result of creativity. The stakes in a trial are simply too high to allow that kind of approach to your inquiry to govern. I mean, to conduct a trial on the basis of and the introduction of an idea that could be characterized as the novel and creative and entirely off the wall but might work kind of idea is just not going to be satisfactory when the result of the trial process is either going to be someone's being deprived of their liberty for an extensive period of time, or someone allegedly victimized being deprived of recovery. So the inherent caution that has to be followed in the trial process is a function of the very different exercises that scientists and litigators are engaged in. And the second thing that comes out of Mohan is that we have a recognition by the court that the strictness with which the criteria applies is on something of a sliding scale. And to that extent, Mr. Justice Moldaver's comments have support in the court in Mohan. The court indicates, in terms of applying the standards at page 415, that the closer the expert evidence opinion comes to deciding the ultimate issue, the more strictly the criteria have to be applied. And that, I think, is an important role for the trial judge, to recognize that there is this sliding scale, and that although in some circumstances the reliability aspect might be met, in some circumstances it just might not be appropriate. And that's why I think, very importantly, we need the trial judge, and that's why you as litigators should be aware of what the expert evidence is going to and be prepared to address the reliability standard with that in your mind.
Thank you. Justice Moldaver, everything that I've seen seems to suggest that at least one of the fundamental bases of this rule is that a jury will accept expert evidence and give it too much weight, and this will distort the trial process. How do you justify the same rule before a judge alone?
Well, I would simply say this, that if the evidence is unreliable, it's unreliable, and it really doesn't matter whether it's me or a jury in this sense. I'm hopefully not going to be confused and confounded and sort of accept the expert because the expert is an expert.
Well, you were confused about Mohan.
The jury is still out on that, my lord. But with a judge alone, I think it's just a waste of time. I mean, if I'm going to let in evidence that I consider to be unreliable and that doesn't pass the Mohan test, then the other side is probably going to want to call expert evidence as well to rebut this, and we've got enough to do without sort of cluttering up the record with a whole bunch of unreliable evidence. So I would just simply say on that basis, and you refer to this in Mohan, I mean, the bang isn't worth the buck. Why sort of waste the time in having a whole bunch of unreliable evidence put before the court?
I covered that too, did I?
Oh, yeah.
Gregory Joseph, is there any discussion of this in the American cases as to how you justify the rule where it's only a judge? I know that most cases are tried by a jury, but there are some that are tried by a judge alone, I assume.
There are many cases that are tried by a judge on consent. In fact, the practice is that judges will allow in a great deal and will not expend the time on that determination, because when you're making the determination as a judge, the reliability standard for admissibility isn't the same preponderance standard for the merits. There's a case called Paoli, which one of our very well-known federal judges, Judge Becker, decided about a year and a half ago, in which he said, the reliability determination for purposes of admissibility is less than proving correctness on the merits, and therefore many judges will simply say they're going to dispense with that kind of an attack on a threshold basis, permitted to come in and be subject to cross-examination, and he or she will determine at the end whether or not they're going to use the evidence. But I think we've established in the Simpson case that we have juries that are not overly influenced by, say, 600 million to 1 odds and by experts.
Well, it sounds like the U.S. judges use this old trick that I used to be annoyed about. They let everything in, and they say, I'll decide at the end of the case whether I use it or not. And then, even though it may have had its influence, they say, I don't have to rule on this now because I'm not using it.
That is the practice.
Ian, Binnie, do you have any opinion on this fundamental policy question?
Well, the only opinion I would care to express is that the question seems to me self-contradictory. You're asking if evidence is helpful, why should there be a gatekeeper as to reliability? It seems to me that if the gatekeeper is supposed to determine whether the proffered evidence is scientifically valid, firstly, and secondly, applicable, until you know those things, you're not really in a position to assess whether or not it's helpful. And therefore, both of those elements have to be addressed at the same time, because they're really two aspects of the same issue. So I object to the question.
I see, okay. We'll strike the question. We'll go on to the next one. Should the indicia of reliability be fixed, and what are they? David Butt?
I'd like to start by Daubert as well as Mohan talks about some of the indicia of reliability, those being in terms of scientific evidence, publication, because publication of course permits peer review, the soundness of the method employed in terms of arriving at the conclusions that are put forward, and whether the scientific exercise that leads to the conclusion is verifiable, and matters like that. In terms of whether the indicia of reliability should be fixed, I say no, and the reason is that we can look historically at things that come in and out of favor. I mean, 100 years ago, phrenology, looking at bumps on your head and telling us what your psychological profile was based on the bumps on your head was all the rage. And so we do advance our knowledge both in terms of developing new ideas and in terms of rejecting older ones, so that we have to, I say, keep the courts open to accepting developments in not only what we know, but how we know what we know. And for that reason, the indicia of reliability should not be fixed. Secondly, there's an issue that you see emerging in the cases, and that is the issue, part of the sort of the eternal war between the academics and the practitioners. And you see people coming to court with extensive clinical experience to offer opinions, and then you'll see people coming to court to offer opinions based on the academic literature and the formal studies conducted. And it's my submission that courts should be prepared to conduct reliability analyses based on both of those two kinds of expertise. And it's easy and it's traditional to look at the scientific literature, but the review of the clinical expert is a little more difficult. But I say keep an open mind about it for this very important reason, particularly in the criminal law sphere. You're not going to get a lot of controlled studies dealing with the phenomena that you're typically dealing with in a criminal law context. Child abuse being a good example. Who abuses children? You just can't set up a controlled study, get a class of people, hive off some of them and expose them to one variable, don't expose the other, send them out in the community and see who abuses the most kids. And in many times in criminal law, you're dealing with violence and other kinds of social issues that you simply don't want to study in that kind of controlled way. It would never pass an ethics committee anywhere. So that in large measure, our expertise is going to come from clinical expertise. And that is going to be a different kind of expertise from the purely scientific. But I say that the need in criminal law is to keep that kind of clinical experience as a viable source of evidence for the criminal process.
Mr. Joseph, the Fry test had one criteria, general acceptance. In Daubert, the majority of the Supreme Court of the United States listed 4 factors, but they said they weren't exclusive. There's been a lot of criticism about Daubert. I suppose there was criticism of Fry as well, but is the basis of the criticism that the criteria, there are too many criteria and they're not fixed, or what is the basis of the criticism?
Well, there are a couple of bases. One is that the criteria don't fit all kinds of testimony, even all kinds of novel scientific testimony. Another is that they're rather general. It talks about, for example, the error rate. It doesn't say what the appropriate error rate is. The scope of Daubert is being whittled down dramatically by our intermediate courts of appeal, some of which say it will not apply they will not apply these criteria to anything other than novel scientific evidence, some of which say they will apply these criteria to all kinds of expert evidence, and it varies literally by your geographic locale. But what the intermediate courts of appeals have done is try to articulate additional criteria, and I'm putting some of those up right now. When Daubert went back down to the Ninth Circuit, Judge Kaczynski, a very well-respected federal judge in California, said a principal criterion for them would be whether the theory or research was generated for litigation purposes. He said, now, you can't over-apply that. Obviously, say, fingerprint evidence would be applied, and a criminal defendant's defense may be expert research that is done for litigation, but if it's not, that would be an indication of reliability, because there would be some objectivity that one would assume. Another case said the degree to which the expert is qualified is obviously something you would look at, that somebody who has gone to whichever of the schools that is preferred would be more considered than, say, someone who's done it all by rote, perhaps, or by learning for purposes of the case. The next one was the relationship of the technique to more established modes of scientific analyses. There may be techniques which are relatively new, but are closely linked to well-established techniques. Another one was the non-judicial uses to which the scientific technique are put. Again, it's sort of the business records theory that if we're doing this routinely, if we're doing it outside of litigation, there is some inherent assumption or some inherent credibility that may attach.
What's your view? Is it preferable to have flexible criteria, or is it preferable to have one criteria as the Fry case suggested?
I think you have to be flexible about it. I think that that's the only way the search for truth can really be advanced. And I think you have to trust in the bridal discretion of trial judges.
With respect to the first criteria that you had up there in Justice Moldaver's example, so would it have mattered if Copernicus was under retainer in the case?
Actually, if he were not, that would actually help sustain his opinion.
I'm glad you're still thinking about that example. You're troubled by it, aren't you?
Well, I want you to understand that was the whole basis for the junk science attack. The book that attacked it was called Galileo's Revenge. Now everything comes in.
Well, now I want to turn to a different question. Should the same indicia of reliability apply to evidence tendered by the defense and by the Crown by the plaintiff and the defendant in a civil case. Michelle first.
I want to take a step back from the point Mr. Justice Moldaver made, which is that maybe there's a different standard whether the evidence is being tendered by the defense as opposed to the Crown. And just remind you that Mohan was a case that was dealing with evidence tendered by the defense. And I think the point that initially caught the interest of a lot of defense counsel was, well, if this is now the standard that applies to defense evidence, it must at least be the standard that has to be applied to evidence tendered by the Crown or by the prosecution. That being the case, arguably things like child sexual abuse accommodation syndrome evidence, which has become, as you know, a very sort of trendy area of evidence for the Crown to rely upon, arguably would now be subjected to the Mohan standard. So I think from the defense point of view, the important point is that Mohan sets the standard not just for the defense, but also for the Crown, and that the Crown should be held to that standard. Now, the point Mr. Justice Moldaver has raised is perhaps one step beyond that, which is, can you in some situations say that, all right, Mohan is the standard, but perhaps we're going to hold the Crown to something even greater? And I suppose an argument could be made that, well, the Crown has the burden of proof in criminal cases. That burden is proof beyond a reasonable doubt. All the defense has to do is raise a reasonable doubt, and therefore perhaps the Crown should be held to a higher standard. The question I have for him is, if we're talking about the danger that evidence is going to mislead the trier of fact, does it really matter at the end of the day whether it's the Crown leading the evidence in order to prove its case, or whether it's the defense leading the evidence to attempt to raise a reasonable doubt?
Justice Moldaver, do you care to respond to that?
In due course. I'm not talking about letting in junk evidence for the defense, and I've still come back to my point that there has to be what I call this basic threshold of reliability. I am just saying that it would seem to me that where the evidence is being tendered by the defense, the reliability threshold perhaps need not be as high as that attributed to the Crown, where the matter goes to the ultimate issue. Mallarney, the case that has been referred to this morning that I wrote, I was talking there about a Crown proffer of evidence. And I made the point that where it goes to the ultimate issue, I would have thought that the threshold of reliability on the Crown's part must be higher, or on the expert's part must be higher. I wasn't talking about defense evidence in that case, and my only concern is this, that, I mean, let's look at Mohan. What if Dr. Hill had been allowed to give the evidence? Well, I'm not too worried about the Crown being able to call experts to debunk and demystify these notions that he's putting forward. Okay, and I'm sure they would have been able to do that without much difficulty, and I suspect very strongly that the jury would have had no difficulty whatsoever in thinking that what Dr. Hill was saying just doesn't add up. Okay, and what if Dr. Hill proves to be right some years from now? Maybe, I'm not saying that maybe there was an innocent man convicted. I don't know. Okay, surely if Dr. Hill, if the victims in that case had been 7 years old, can there be any doubt that Dr. Hill would have been able to give evidence that this is a crime committed by pedophiles? I mean, that's accepted now. Well, science advances, the social sciences advances, maybe Dr. Hill will be proven right in time. I don't know. And I'm not worried about the Crown, as I say, having the opportunity to come back with their own people, okay, and try and demonstrate that Dr. Hill is all wet, and let the jury decide it, where the issue is something that might help the defense. That's all I'm saying.
David Butt, what is your view with respect to whether the same criteria apply for the Crown and the defense?
I must say I am attracted to Michelle's analysis that Daubert is the greatest of respect.
Oh dear.
The Daubert, I'm sorry, the Mohan case is not speaking when they're talking about the discussion of the standard, about defense evidence. The discussion there is framed in general terms, and I would expect that everybody would be held to the same standard. On the other hand, you do have, and this is where I get to Mr. Justice Moldaver's analysis, you do have that comment in Mohan that the closer the issue gets, or the opinion evidence gets to the ultimate issue, the stricter the standard is to apply. So that I think what we're talking about is a differentiation in degree, but a very subtle differentiation in degree that recognizes the basic principle of reliability and not distracting and exposing the jury to extraneous matters. I might add that some of the perhaps complaint that comes out of Mohan arrives out of the fact that in the Court of Appeal, the analysis proceeded on the fact that, well, what's fair game for the Crown in terms of calling similar fact evidence to prove a sexual assault like this ought to be fair game for the defense in terms of proving that the offender is not of the class of people that would commit that kind of offense. The Supreme Court addressed that specifically and said it's not a sauce for the goose, sauce for the gander issue here. Those are very different things. The distinction to be drawn is between the specific characteristics of the act, which is similar fact evidence, and the profile of the offender. And the court said the reliability of the evidence on profile of the offender, as found by the trial judge, was not sufficient to warrant the introduction. So don't, on the defense bar, conceive of Mohan and its movement from the Court of Appeal to the Supreme Court as a rejection of sauce for goose, sauce for gander. I think it does apply a standard that is to be respected across the board, subject to that shading as you approach the ultimate issue.
Justice Moldaver, you want a sewer rebuttal?
Well, thank you very much. I appreciate that. I just wanted to set out to you, we talk about this Frye test and the general acceptance in the scientific community. And I just want to point out to you what one of the United States courts, federal courts, in a case called Downing, U.S. and Downing, 1985 case. I mean, the concerns with this Frye test are threefold. The relevant scientific field is difficult to determine. The level of acceptance within that community may be difficult to gauge. And the test may exclude probative and reliable scientific evidence because the technique has not been sufficiently established in the selected scientific community. And this is what worries me again when I come back to the defense proffer of evidence. And I ask you this, I mean, what if you got 52% of the people in the field, if you could ever figure out who the people in the field were, saying, oh no, this is bunk, and you got 48% of the people saying, oh no, this is good stuff. Well, what does Frye say about that? I guess it hasn't been accepted within the general community, therefore it's out. I mean, there are real problems with the Frye test with respect, and that's why I like what the Supreme Court of the United States did in Daubert.
Well, I think some of the later cases say in that sort of situation in the United States, the trial judge would determine that as a question of fact as to whether or not it's generally accepted, and he might go with the 48%.
But do you have to sort of call the evidence?
We have to leave something for the trial judge, you know. In the United States, as I understand it, and Gregory Joseph they actually call evidence as to the degree of acceptance. Is that not correct?
That is true. That's still true, say, in New York State, where Frye is in effect. But there are difficult cases. The difficult case may be in an economics case, for example, in an antitrust case where established doctrine is that everybody for 50 years has thought one thing, but somebody writes a new article, and everybody who reads that article agrees, you know, we've been wrong, but only 10% of the economists have bothered to read the article. On the other hand, judges say, well, if I don't have general acceptance, how am I supposed to know what's reliable or not? So there's no real winning the argument.
What about if 40% of the economists have not read it but have talked about it over coffee? Does that make it?
That's it. Ian, Binnie, assuming this test applies in civil cases, would there be any difference between admission by the plaintiff or the defendant?
I don't think there would be. I think it would apply equally. I think the problem on the civil side is really how deeply down into the bowels and recesses of the system do you reach. I mentioned earlier this morning the evidence that's proffered by so-called experts before various tribunals, which I don't think would meet any of the tests that Greg put up. That is to say, so-called economists appearing before the municipal board practice an art which is not only generated for litigation but is only recognized in the Ontario Municipal Board. across the whole planet. The qualification generally is that you're an executive of a bankrupt store chain. Relationship to more established methods of scientific analysis. I don't think a professor of economics at the University of Toronto would even understand what the term department store type merchandise means, and yet it's the whole foundation of the art. And non-judicial uses. No one in their right mind would rely on that kind of analysis to make an investment decision. And yet this kind of evidence is regularly adduced at the municipal board, but different types of comparable expertise are all over the municipal and administrative tribunals in the province, so that junk science is alive and well in Ontario. The only question is, where are you going to look for it?
Thank you. Well, we've been dealing at the level of theory. Now let's see whether this theory can be put into practice. Let me give you an example, get your opinion on it. It's a sexual assault case, and the complainant is 3 years old and gives a detailed description of the sexual assault. The Crown calls a psychologist who testifies that he or she has interviewed hundreds of children who were the subject of sexual assault, and says a child of this age could not make up this story, the inference being the child must be telling the truth. Is that admissible, Justice Moldaver?
Probably not. I would doubt that it could be determined at this point, and I'm applying now the Fry test to this because it's a Crown proffer, and it's going to the critical issue in the case. Is the child telling the truth? So unless it could be established that this was generally accepted amongst the scientific community, I would say no. But beyond that, even if it were, and I would think it would come very close to, if not being oath helping, and so I'd have some difficulty, but that's just off the top.
David?
I share the concerns about oath helping. As Crown, I might tend to argue, as I mentioned earlier, that it's the clinical foundation that offers some validity for the opinion. So they're really two separate issues, whether it's oath helping, and you know from the four Mohan criteria, inadmissibility on another ground, another exclusionary rule, is the end of the story, even if the evidence is reliable. So that's Justice Moldaver's concern. It's a fair concern. Setting that aside, I'd say you argue on the basis of the vast clinical experience and make the argument that clinical experience is relevant. It's not just the scientific kind of experience. I'd like to just spin away from the actual answer to the question to say also, from the perspective of conducting litigation, do you necessarily want to turn that question into the battle of the expert? You have a jury sitting in front of you as a Crown, and if the story comes out in great detail, the jury members are going to be able to form a conclusion on their own as to whether a 3-year-old can come up with a detailed story like that. Do you need to turn the criminal trial into this kind of battle of the pseudo-scientific psychological experts when something like this is readily apprehendable by a jury, particularly as time goes on and people are more sensitive to the issues surrounding child sexual abuse?
Wouldn't you want to know whether or not there's some acceptance among psychologists that a child of a certain age can't lie and can't make up a story?
Yes, I think that has to be part of your analysis. But what I'm saying is that the clinical experience can be taken into account as an important factor. But I quite agree that the psychological studies are going to be helpful. What you see so often, though, in the terms of what we might call the soft sciences, is that you can find studies going any which way you want, including both ways at once if you look hard enough.
Gregory, Joseph, what would be the result in the United States, do you think?
Well, there are a lot of cases actually on the issue, and in the vast majority, expert evidence as to credibility is excluded. And it's excluded for a number of different reasons, but that's a pretty uniform result.
As oath helping it?
Exactly right, that you're just buttressing the testimony.
Does anybody think it's admissible? No answer.
Well, are we going to read about this soon?
Well, I'm thinking of bringing a case so we can get an answer from our court. This will be the last question before we take questions from the floor.
Just here, what about if the defense tried to bring in a psychologist to say the 3-year-old is subject to certain vagaries in the evidence? Would you change your answer?
Well, again, bear in mind, just because it's the defense, I still would want to see some threshold of reliability. And when you read, if you read Malarney, you'll see what the kind of the things that I'm thinking of. And I'm not going to let in something that is mere speculative hypothesis. But if there is some basis for this, okay, and it may not be generally accepted, but there are some indicia of reliability. There may be some articles out there or something, even though it can't be demonstrated that the psychological community has accepted it. I might well let it in, subject, of course, to, I mean, you know, I've got to follow the law in the Supreme Court of Canada, and right now, as I see it, the law is, as Ms. Justice Sopinka has set it out, and I would follow that. I'm just talking, really.
Very humble. What are there categories of novel scientific evidence that have gained acceptance by reason of being previously recognized by judicial decisions? Michelle, first.
I think that there are categories of evidence, particularly behavioral science evidence, that previously were accepted by courts, but about which one could now say counsel could go back and challenge admissibility. And I'm thinking of things like behavioral indicators of child sexual abuse, the child sexual abuse accommodation syndrome, battered woman syndrome, perhaps even rape trauma syndrome. And the reason I say that is that in the pre-Mohan decisions, it seems to me that this evidence tended to be accepted without a Mohan kind of analysis being applied by the judge. That being the case, counsel could now stand up and suggest that the evidence has to be reassessed in accordance with Mohan. Secondly, I think it's important to bear in mind that when you're dealing with areas of novel scientific evidence, particularly behavioral sciences evidence, likely the state of knowledge is going to change over time. And if you take an example, Dr. Roland Summit came up with this child sexual abuse accommodation syndrome, and he said there were 5 indicia, and if a child met all 5 of those indicia, you had an abused child. Experts started coming to court on behalf of the prosecution and parroting Dr. Summit's syndrome. Then, when some detractors started to criticize the basis for the syndrome, Dr. Summit turned around and said, oh, you all got it wrong. Really, I was talking about indicia that are reliable in the therapeutic context. In other words, when I am trying to give children who have been abused therapy to help them get better, then I can use and rely upon these 5 indicators. But I was never suggesting that a court searching for quote-unquote the truth should be using these indicia. So that's an example of one area of behavioral sciences information where indeed the state of knowledge has changed over time. And I think it's fair to say that counsel have to be on the alert for the development of the state of knowledge within the particular field. And it may well be that over time what we once viewed as being admissible and acceptable and valid will be shown not to be so.
Thank you, Michelle. I'll open it up to questions from the floor. And please direct your question to either a specific panelist or one member of the panel. Yes?
Mr. Joseph, what use is being made in the United States of the Federal Judicial Center Reference Manual on Scientific Evidence?
The question, if you couldn't hear, was what use has been made of the Federal Judicial Center's Reference Manual on Scientific Evidence after Daubert got rid of the Frye test. Judges started asking the question which I raised a few moments ago, and that is, how am I supposed to know what's reliable or not? So the Federal Judicial Center distributed to every federal judge in the United States, and it's now widely available, a very thick text which deals with specific areas of expertise to give judges a fundamental grounding in things like epidemiology, things that in mass tort cases may be important. Together with a synopsis and analysis of the Daubert opinion, and it's very widely used. It's cited by people making arguments pro and con. In the United States, under our practice, particularly in civil cases, whether or not expert opinion comes in may dispose of the case. It may be disposed of on summary judgment, and that manual is relied upon a great deal in those kinds of hearings.
Yes?
I was wondering if I could ask Mr. Binnie to return to the issue of preparing one's experts' reports and what his practice or views are on keeping drafts, and that it seems to arise every time we have it, and different experts have different views. Some say, well, I'll just do it on computer, so there won't be any drafts. And I'm wondering if perhaps Mr. Justice Moldaver, as a trial judge, could comment on what inferences he might draw, what view he might take of that issue if it arises. Whether, if somebody's asked, where are they? They say, well, in the garbage.
Well, I guess, firstly, I'm not sure there's a distinction between hard copies and computers, because there are programs that can unwind the computer and bring back data which has been entered and then you think obliterated, but in fact just shoved to another part of the memory. I think it would not be proper to suggest to the expert, that it might be embarrassing to keep drafts and therefore they should be disposed of. But I think there's a legitimate question as to what use retention of drafts serves in the process. And it's really very much the same question as arises in media cases as to whether they keep notes and outs from television interviews and so on and so forth. I think that the discard should be based on utility and general practice rather than some instruction to get rid of it to avoid embarrassment in the litigation.
I could say a couple of things. But you want me to say something, or do you want to?
Yes, no, I won't. You answer it.
Well, this is not definite or anything, but I would think it would be foolish to ever tell your expert to destroy papers. Surely he or she will be able to explain, or should be able to explain, that which he or she has written down on a prior occasion. But I can tell you right now that in cross-examination, if you were able to demonstrate that this expert has destroyed anything in the file, even though he or she says it wasn't really important, it was just I just jotted a note down, I think that it's going to have a tremendous effect on their credibility, on their reliability as a witness, and it might well cause the judge, I don't think it would render the evidence inadmissible, but I think it might well cause the judge to give the jury instruction about the weight that they consider that evidence should have, bearing this in mind. It'd be up to the jury, or up to the trier of fact if it was judge alone.
Can I just add a point? It goes back to, I think, what Eleanor Cronk was saying this morning, which is if you've got the kind of expert who is prepared to significantly change his or her opinion because you don't like the opinion that's been expressed in the draft report, then I think you've got an expert that you really don't want to use in court. It seems to me that the purpose of a draft report is, from the expert's point of view, to ensure that he or she hasn't overlooked something or misunderstood something in the information that's been provided, and that the purpose of the draft is not to ensure that the expert is providing you with the opinion that you want at the end of the day.
Yes? Do you want to stand up and state your question so that everybody can hear it? I'm not sure they hear the question.
I just wondered to what extent the panelists feel it might be appropriate or helpful to legislate the acceptability of scientific expertise or data to some, for example, similar to the minimum impairment of blood alcohol level, in the sense that that's been determined as more or less a legislative fact to establish impairment. And are there other areas in which that sort of analysis could be, that sort of deemed expertise could be legislated?
Have they done that in the United States? There's the federal rule, which states a general rule, which you could interpret it in a number of different ways. But I mean, apart from that, is there been any legislation that this is a field that is where an expert can testify?
The only example is when Congress takes it upon itself to change a judicial opinion. After Ronald Reagan's would-be assassin was acquitted on an insanity defense, Congress legislated a rule saying that there shall be no testimony as to whether a criminal defendant has the requisite state of mind. But except for a rare case like that, and Congress does occasionally draft rules of evidence, it's primarily done on a rulemaking basis, which is of the general sort that I just had up a few moments ago.
Well, does anybody think that the categories should be codified by legislation? I think it would be too inflexible, but I mean, there's no reason why the legislature, if they thought a particular category it was important enough, couldn't legislate. I don't know how helpful it would be, but it settled it. Any other questions? Yes.
I'd like to ask a question about new methods of presenting evidence. I'm specifically thinking of computer forensic animations, which I know that Mr. Joseph has a great deal of knowledge about. The use of experts to introduce new technology method or presentation methods itself. Could you perhaps comment on that?
Well, the practice in the United States is to attempt to do that as much as possible in advance of trial, outside the presence of the jury, and depending on the nature of the animation, you may require, you have two levels of authentication. You have the underlying theory, which has to satisfy Mohan, and then you have the translation of the theory into the mathematical formula, and that itself has to satisfy Mohan. So that at both levels, you have to make sure that your formula incorporates all the real-world variables that it's supposed to, and that it's factually based.
Yes?
This is more for the judiciary on the panel. If you accept Michelle's point, which I do, that the problem here is really timing, that you have an emerging body of knowledge, and then you have a retaliatory body of knowledge coming in. And I can think of several examples recently, refreshing memory of sexual abuse victims, multiple personality disorder, where there's heated controversy that erupts afterwards, and yet there's judicial pronouncements once an emerging body is there. You accept Ian's point that the judiciary or administrative tribunal will put in whatever evidence they can, or at least accept expert evidence on points. Do you think there's a willingness among the judiciary to overturn judicial pronouncements that they make based on emerging knowledge, based on retaliatory knowledge that comes out later? Because once you have the Supreme Court of Appeal pronouncements, it's treated as almost ornamental. It's there, we can't touch it. And the lower courts treat it that.
Justice Moldaver?
Well, I think absolutely, and I hope we would not, I would certainly seek to distinguish a Supreme Court of Canada case based on the fact that new information had come forward. And if you look at the case of Madam Justice Sharon in Olskamp, which is reported in the CCCs recently, I think it's 95 CCC or something like that, you will see that Madam Justice Sharon refused to admit evidence of this sexual abuse syndrome because there had been other studies that were put to the expert in cross-examination to demonstrate that this was a lot of theory. It really wasn't scientifically accepted. So my answer to you is absolutely yes. I mean, if the Supreme Court of Canada ruled X today and the science or the perception of the scientific community changed on it, then, as I say, I would seek to distinguish the Supreme Court of Canada case and say there's been a change, and then I would get overruled.
Well, I don't think you'd have to distinguish, because I doubt very much that we would say as a matter of law that this body of evidence is accepted or not accepted. What we would say is there's been a finding at trial that it is or isn't. And I don't think we would ever say, well, we were deciding it as a matter of law, and no matter what the trial judge finds, it's admissible or inadmissible.
But let's take an example. Let's take Lavalley, for example, or some of these cases involving expert evidence designed to rebut misperceptions or that might be in the minds of the public. As the public becomes more educated about the battered wife syndrome or battered spouse syndrome, and more educated about how children react in sexual assaults and so on, and it's that they often recant, If that becomes a matter of public knowledge and within the experience of those who form our juries, why do we need experts anymore? And ask yourself this question. If you're in front of a judge alone, who by now is well aware of the fact that children recant, okay, and that some children wet their beds and so on and so forth, why do I need an expert to help me out when the Crown seeks to call that expert? It may be that I don't anymore. Maybe I did 10 years ago because really none of this was all that much in the public purview, but now it is, and so think about that.
Well, it may be excluded under the helpful requirement, because if it's no longer necessary,
That's right.
because it's so well accepted.
That's right.
But beyond that, I think you have to know your judge and or know your case that you're dealing with, and you may be potentially opening your case up to distractions that will take away from the substance of the arguments you have to present by needlessly junking up the case with experts. Just on the development of new ideas principle, a case like Parks in the Supreme Court of Canada is a classic example of how the court said, look, on these facts we're not going to recognize the automatism. Well, they upheld the acquittal, but said on these facts we just don't have enough evidence to make any kind of pronouncement on insane versus non-insane automatism. That's not to say that in the future we won't. So I think to that extent at least there's Parks recognizing that the courts are going to leave themselves open to new scientific developments.
Well, I think that we've exhausted our time in some, and so I'd just like to thank the panel, Justice Michael Moldaver, David Butt, Gregory Joseph, a special thanks for coming from New York, Michelle Fuerst, and Ian Binnie, and thank you for being such a good audience.